If you're here in this room, it's because you know about New York Labor Law Section 240, commonly known as the Scaffold Law, and how it affects building owners and the real estate industry here in New York day to day. So we're grateful to Chris Jaskowitz of Gotham Organization, who was the driving force really behind today's program and helped line up this morning's esteemed panel of experts on the topic. Chris is Gotham's Chief Operating Officer at Gotham, whose affiliated entities own and operate approximately 3 million square feet of residential and retail properties. Its construction arm, Gotham Construction, we all know, is one of the oldest and largest builders in the Northeast. Now in his 10th year with the company, Chris oversees building operations, retail, commercial leasing, and the company's legal department. He's also involved with corporate strategy, risk management, and insurance, which brings us to our topic for this morning. So I'm now pleased to introduce Chris, who will kick off our program. Thank you.
Thanks, Jonathan, and thank you to everyone who came this morning to be here. Now, my guess is some of you know quite a bit about 240, which is one of the names for the Scaffold Law. 240, Labor Law, Scaffold Law, it's all the same thing. Some of you probably know a lot about it, and my guess is some of you don't know much about it, but you're curious. But one thing I've learned is that people that even have a moderate amount of knowledge about this law know that it is one of, if not the biggest issues facing the New York City and state real estate industry. Why is that? Well, it's because it hurts businesses of all sizes, large and small, and all types of businesses. What do I mean? Take a small contractor. This law is creating a circumstance that insurance rates are absolutely skyrocketing right now. And if a small contractor can't afford insurance, it can't be in business. So that would be good for the large contractors, right? Not the case. Large contractors, when they put together their pricing and their package for developers who are developing projects, a line item is obviously insurance. And if that insurance line item is out of whack or too high, the developer doesn't do the job. Or it scales back its renovation job. Or it delays the project, or whatever. And if that happens, that large contractor can't hire their 30 to 50 subcontractors, which largely are small businesses. And those small subcontractors can't then hire their own subcontractors. So at that point, you're talking about hundreds of small businesses that aren't hired for that project or scaled down for a smaller project. And that's only one piece of it. At Gotham, we have a construction business, and we also own buildings, and I see the construction piece of what I just described, but also on the building side. It's amazing to me how many small businesses are sustained due to the operations of large buildings. Everything from IT to cleaning to landscaping. These are small businesses that don't get work if a building isn't built. So that's how this law is hurting New Yorkers. Today's panel is, it has to be, the best panel ever assembled for this issue. And I say that because all the key perspectives are represented really for the first time. And I'll go through the process just like a development goes through its process. It starts with a developer. The developer obviously comes up with a vision, analyzes the costs, arranges financing, and it has to make sure that the end product and the revenue derived by the product justifies the cost and the risk, right? So our developer perspective is represented by one of the most prevalent developers in New York and nationally, the Related companies. Specifically Craig Gushee. And Related does everything. They do rentals, they do residential, they do commercial projects. And Greg is a senior vice president at Related. He's the project executive for many of the projects that Related develops. And his most recent one was MEMA, which is an award-winning project on the west side, 1.2 million square feet, terrific project. We also have a public developer represented by the School Construction Authority. The SCA is a state agency, but it's responsible for the 1,500 schools in New York City. And they have a $2.5 billion capital budget every year for the construction and renovation of school projects. Ross is the executive vice president and general counsel of the SCA. And he's on the executive committee. He's responsible for real estate, legal department, and insurance, risk management. So we have developers represented. The next step is the contractor, because you can't build unless you have a contractor to kick around. And who better to represent the contractors than Lou Coletti, who is the president and CEO of the BTEA, the Building Trades Employer Association. Lou represents 1,800 contractors, so he's a perfect person for this panel. And he is a leading voice in the construction industry on all issues in our industry, ranging from labor relations to safety, everything. So we have the developer, contractor. The next thing you need is insurance, because you can't build a project without insurance. And specifically today, we're talking about liability insurance. The first step to get an insurance policy is to talk to a broker. The broker that we have represented on the panel is Alliant. They're one of the largest in the nation. We have Kevin Dolan, who's their senior vice president in charge of their operations for the East Coast. Kevin's been in the industry for 16 years. Doesn't look like it, but it's 16 years. So the next, I'd say, relatively important part of the process is the actual carrier. And who do we have? We have the biggest in the construction industry, if not other industries, AIG, sometimes known as Chartis. Representing Chartis, AIG is Chris Murray, who's claims counsel, who is in charge of handling the claims, and he has a terrific historical perspective on 240 law. The final step, and this was an important part of this panel, the final step is to have a litigator here who can really walk us through the process of litigations and settlements in the 240 world. A lot of us think the real world is out here, but not in 240. All the money that's paid by carriers and by owners and contractors goes through the lawyers in these litigations and settlements. And we have Cozen O'Connor represented. Cozen is a national firm, lots of different departments. They have a litigation department, and a sub-part of their litigation department is construction defense. Part of that is this 240 area, this labor law, scaffold law area. And Vincent Pizzuto is one of the leaders in that 240 area. So I think what we should do is start really with you, Vincent, so that you can tell, just explain, what is 240 law, please?
Sure thing. Thanks, Chris. 240 is a statute that applies to owners and general contractors. The legislative history of the statute was that the legislature wanted to protect workers. And if you read the legislative intent, it actually says, we want to protect workers. They can scarcely do it for themselves. So we're going to put the onus on the people who we think should protect them. And they came up with owners and contractors and their agents. Now, the cases interpreted 240 for years.
Let me just enter. What does the law mean itself? What does the law mean? When we say absolute liability, what does that mean? And, we'll get into the history in a little bit. But
sure.
What does the law mean?
The law means it puts the onus on owners and general contractors to provide what's called in the statute adequate protection to workers who are using ladders, scaffolds, but really it applies to any heights, any gravity-related event. And as we move on, I'll point out some examples about the breadth of the gravity-related event, what it could be to apply. But the main point I think Chris is getting at is it establishes absolute liability, strict liability against owners and general contractors. And for those who don't know what that means, it means liability without fault. An owner does not supply scaffolds or ladders to a subcontractor's employee. A general contractor doesn't do that either. The law says we don't care. If they don't have the right equipment, you, Mr. Owner, you, Mr. General Contractor, are strictly at fault. It's liability without fault for a violation. And the second part of it, which is why, a big reason why we're here today, is the cases have decided that the way that statute's written is comparative fault of the plaintiff is not a defense. The plaintiff's comparative fault cannot be used as a defense.
So what does that mean, comparative negligence?
Well, in a straight negligence case, a slip and fall on the street out there, you sue the building owner for the sidewalk's got a crack in it, and you say, you should have known this. It's a big, big crack. In a straight negligence case, you can go to court and say, all right, well, maybe the crack was there, but it was big enough for you to see, and you could have got around it, and a jury decides the apportionment, 50% owner, 50% plaintiff. And in New York, the way that works is if they get an award of $100,000, 50% comes off. They get $50,000.
They take into account the injured person's negligence.
Own culpable conduct. And we don't have that in 240.
Okay, 240 is not. It's absolute liability to contractor developer.
Absolutely.
So let's move to the history of 240. I think it's very interesting. I've heard Chris talk about it. Chris, could you tell us about the history of 240 law? Please.
As we're talking about this, there's something to keep in mind. It started as a good law. I'm going to say that flat out. A lot of bad laws started out as good laws, and this is one of them. 1885, I'm not going to go through the whole 100 so years, but 1885, around the time they're building the Brooklyn Bridge, there's a huge spate of accidents, death accidents. You've seen in some of these older constructions the plaques to people who died from height-related injury. And the reaction in the press was pretty strong, and they passed a law making employers, it's key that the first law was to make employers responsible if they didn't have a proper scaffold, right? This is back in the wildcat days of New York construction. Now, started out as a good law. It had nothing to do with what you just heard about absolute liability or anything like that. It just said you had to use good scaffolds when you're building these big buildings. I'm going to fast forward a little, skip over some history, but eventually they expanded from scaffolds to ladders to using the right harnesses to falling objects. But in 1969, it's important to remember that for another reason, but in 1969, with the push of labor, they passed a law to make it more like what the modern labor law is and saying, you know what, we're not going to just blame the employers, all right? Employers may not have enough money to cover these claims. We want to go, and in all fairness, whether they say it in the statute or not, we want to go to the deepest pockets we can find. And that's the general contractor and the owner. And if the general contractor doesn't have money, we'll go for the owner because at least we know he owns the property. And that's why they made the law against them. It doesn't matter if they knew what was going on. It doesn't matter if they caused the defect. It doesn't matter if they transferred everything down to the responsibility of the worker and the contractor. We're going to hold them responsible for any height-related accident. Why does that matter that it was 1969? I just make that. Because in 1970, they passed OSHA. All right? And I bet, if you're not familiar with the labor law, I bet everybody in here is familiar with OSHA. Sitting on my desk and sitting on a bunch of your desks is regulations controlling how a work site's supposed to run, about this thick for construction sites, including height-related devices. But New York decided to be in advance. By the way, and this definitely keep in mind, no other state has anything like this. All right? We practice in 50 states. AIG covers the world. And no other state has a law like this. Every other state, you have to show that somebody did something negligent. You have to show that the general contractor did something negligent, knew something or did something. New York, you don't require that. We decided to be in advance of OSHA and make our own regulatory scheme. And then when OSHA came out, we didn't change it. And over the past 40 years, I don't want to jump ahead, but over the 40 years of very easy claims, this is easy, the easiest type of case. Any plaintiff's attorney would be thrilled to get a labor law case because it's very easy to win. Awards got bigger, workers got very cognizant of it, unions got very cognizant of it, and it's changed construction in New York.
So let's go right to the developer standpoint. Greg, how does the existence of this law impact a developer like you?
It's huge. And this law has sort of gotten much worse in the last 12 months, and so it's really come to our attention. But really, when you look at a project and decide whether to go or no go, whether you can afford to build it, you look at the costs and the revenue side, right? And a hit like this, which is probably equivalent of 4+% of construction cost, is huge.
Meaning
right?
4% attributable to this existence of this law.
So insurance now is, say, 8% in that range, when actually it should be more like 3.5% to 4%. So 4.5% is attributable to this law. And that's defined because we know what it is in other states. And so that's what this law is costing the jobs. So when the project is burdened by this law, this extra 4%, we have to either not go ahead with the project, right? And that is big enough to have a material impact. And even if we decide to go forward, we have to find that 4% somewhere else. So it puts cost pressure on everything else in the job. Subcontractors, labor, everything is on the table for trying to find a way to make this project go forward with this added burden. And then in any case, we go forward, any additional cost ultimately has to be made up by higher revenue, right? Which is higher rents, higher sale prices. So it has a negative effect to sort of everybody, right? And the last sort of part of this is that one of the hardest jobs to get financing for is rental and affordable housing. And so when this cost pressure comes down, it puts even more pressure on development of affordable housing, which is very important to us and to everyone in this room, I'm sure.
What's the scale of 4% on a project of this type that you develop?
So I take a typical 350 unit multifamily building, right? That's probably $100 million construction budget. That's $4 million. That's $4 million that could tip the scales to making the project not go forward, or actually we have to find somewhere else, either in other cost line items, reduced scope, or in higher revenue.
Meaning higher revenue if it's a condominium or rental project, higher rents.
Right.
It's a commercial project,
right.
Higher rents on the commercial tenants.
It has a multiplier effect and trickles through everything, right? So it's probably higher rents need to be underwritten, higher sale prices, results in higher permanent insurance costs because the replacement cost is more. And so it has this sort of ongoing impact, not just for the construction phase, but forever, for everyone, for where they live, where they work.
Good. And so Ross, on your side, and as a school builder, what are your thoughts?
Well, I think it's on. At the SCA, we're not looking at the bottom line or profit or anything like that, but we have a very significant impact as well. Let's say our insurance, we have a wrap-up insurance program, so we cover every contractor on our projects of any tier, the City of New York, the School Construction Authority, and the Department of Education. We spend approximately $100 million a year on our program. Our construction value is about $1.7 billion this year. In the past, it's been as high as $2.2 to $2.5 billion just in construction. So we have been advised by our program manager that if we took our same book of business, the same amount of construction that we do in New York City, and move it to New Jersey, and ferry the kids all over there, that our insurance costs would be approximately $25 million a year. So $75 million a year extra we're paying for insurance to build schools in New York City. That's a school and a half or 2 schools every year that we're not building. And the reason for that is we get an allocation from the city. It's a zero-sum game. So if we're putting extra money into insurance costs, that's another dollar. If every dollar we put into insurance, that's $1 less we're using to build schools. It's not as if the city or the state is going to come up and say, gee whiz, I see it's costing you a lot more money, so we're going to give you more money to keep your program alive. That's not the case. We have to take the money that we have and then apply it to the insurance program. And given the fact that the needs of the city are great, with our 1,500 school buildings, as Chris mentioned, we're building 15 or 20 new schools every year. That's a significant impact for us and for the school children of the city of New York.
Thanks, Ross. So, Lou, how is this affecting your constituents?
The 240, 241 legislation has now, in my opinion, threatened at such a level, it threatens the very economic viability of contractors, whether you're a general contractor or construction manager, and threatens the economic growth of this city. That's where the costs are. If you look at it purely from an insurance premium standpoint, my contractors tell me that their premiums have increased over 300% in the last several years. We all know, if you're contractors, or at least contractors feel this, that prices are still really down. Nobody's making any money. I've talked to contractors who have lost jobs because they've tried to reduce every other element within their construction budget and can no longer compete. On the other hand, I think it really threatens the economic viability of this city, because when the construction costs, we talk about land costs, and construction costs are high in New York City, and everybody looks at land costs and the public review process and labor costs. Yet this is the silent killer, 240, 241, because that developer may say, you know what, I've got everything else in line, I just can't, the numbers don't work. Okay? I had a mechanical contractor tell me yesterday, to prove Ross's point, he bid a school in New Jersey, a similar scope to a recent job that came out. His insurance premium was 75% less. Everybody looks at the large construction manager, and that's only one element of it, right, is the premium. The second element of it, which is crippling this industry, are the suits, the settlements, multi-million-dollar. I mean, what I would do is ask you to compare this with if you were charged with a crime. You go into court, it's your decision, you have an opportunity to take the witness stand and present your side of the story. On 240 and 241, you don't have any right. Whether that worker came back to the job after a couple of drinks, whether, in my case, I represent union contractors, employers contribute millions of dollars a year to a training and safety fund. If they ignore a rule, I mean, the iron workers, I think, are a great example. There's an OSHA rule that says you must be tied off 6 feet or above. Try to get them to tie off at 6 feet or below. And if they get hurt, guess what? You've not only got a 240, 241 claim, but at the same time, they're collecting workman's compensation insurance. So I think we're at a stage now that this bill really threatens this industry, and many of the small contractors, I mean, Chris mentioned the smaller contractors. Everybody looks at the marketplace and sees the big players. But I saw a recent statistic that showed that 75% of the construction contractors in New York City employ 25 people or less. They're going to go out of business. And if they go out of business, the construction managers will have no one to hire to build the project. So I really believe that the time is now, or we're just going to continue to suffer economic consequences both for contractors and the city as a whole.
It seems, Lou, that if this law is disproportionately affecting these smaller businesses, it seems that a lot of those smaller businesses are startups, including women and minority-owned businesses, that are also disproportionately hurt by this law, right?
Yeah, there's no question about it. If you're in the construction business, you will be negatively impacted by this bill. And many of us in this room, on this panel, have been fighting this for 20 years. And Joe Hogan from AGC had a great line earlier. I was talking to him. I said, we're going up for our annual beat your head against the wall discussion in Albany. And he said, yeah, but it doesn't hurt as much. We've been through this before. Okay? There is a solution to this. But right now, the politics are so skewed against us. It's basically labor unions have created a partnership with the trial lawyers. And you go talk to any elected official in Albany, the governor's office, and the coalition that we were on just was up. And what do they say? Well, what's labor's position? So we've really got a battle on our hands because I think someone was mentioning, I think maybe Chris, that we're the only state in the country that has this bill. Illinois was the last one. When they got rid of it in 1995, their construction employment levels, they gained 50,000 jobs.
So let's get into that a little bit. And I want to come back to the notion of being fair to workers and having laws in place that are fair to injured workers, because I don't think anyone here would ever say that we don't want workers that are injured protected and covered. But before we get into that, Kevin, tell us about other states, please. I mean, you are familiar with the industries nationwide. I'm particularly interested, I think the audience would be particularly interested in knowing more about New Jersey, a mile that way, Connecticut, a couple miles north, and also Illinois, which was the last state to have a similar law that was overturned.
Well, first, let me thank you, Chris, for hosting this panel, and Jonathan and the rest of the user council, because I think it's very important that the story needs to be told both from a supply side as well as an end employment side. And personally speaking, I tell a story about a year and a half ago. I went to see a contractor that I'm sure you all know very well in this room that was rebidding a job that was put on hold around the Penn Station area. And he called me up and he said, we need some numbers for the wrap-up. And I drove up to see him, and I told him what the primary cost, and it wasn't a good reaction. And then I opened up the excess file, and the excess file was, he showed him a number, and he almost blew a gasket. And then I said, listen, we haven't even gotten past the first $2 million of excess yet. There's another 98 we have to go through. So conversations like that gave me a lot of gray hair. So personally speaking, we need to do something about this before it's all gone. From a New Jersey standpoint versus a New York, it's a very good point, because you look at an average project size of around 100 million or 50 million, and you're looking at insurance cost all in of around 3.5%, give or take, for New Jersey. Those same project costs in New York, depending upon who is bidding the job, could be 8%, could be 11%. And it's very important based on who is bidding the job, because I think we've talked a lot about the unfairness to the small contractor. And then there's almost a belief that there's an advantage to a big contractor. Well, really the advantage right now in the marketplace, there's no advantage for New York, but when you talk to underwriters, their first question is, well, if I'm going to write this opportunity, how much work is really outside New York? Because they don't want to have all their eggs in one basket. So the advantage, if you will, is being placed to the firms that have the most work outside of the city. And that leads to a disadvantage for not only the New York-based contractors that do most of their work here, but also the smaller firms and so on and so forth. And I think that's a very key part. You know, when you look at pricing, it's not uncommon to have pricing to be 2 or 3, potentially 4 times more expensive just for New York work. And that does not exist in Connecticut. It certainly does not exist in New Jersey. Following on what Lou was saying about Chicago, we've done a lot of work in Chicago, and Chicago is a tough area, both from a jury pool standpoint in Cook County. It's very similar to New York in the fact that you have a big state with a big hub in downtown Chicago. But it is very clear from all the stats say, and Lou was talking about this, it's post the repeal in 1995 of the labor law, or the scaffold.
Illinois had a labor law analog, right? Similar
Yes.
to 240 law.
Correct.
And they repealed it in 1995.
1995.
What happened?
And the first thing that happened is workers' fatalities went down. Okay? Work went up, union employment went up to $50,000 statistically. But most importantly is workers' fatalities went down. And when you look at the numbers, it's tough to draw that conclusion, but when you really look at what really happens, right now everyone's painted with a broad brush in New York, okay, for safety. You can be the safest contractor in the world, or you can be unsafe, and the insurance company is not necessarily going to give you that discount right now because of New York, and there's very little that you can do based on what we heard before, what happens when you get in the courtroom. There's no defense, there's no comparative negligence. But when you look in other states where if the workers didn't tie off and then there was a greater focus on safety because of it. Because it separated one contractor from the other, and owners really had the drive to award the safest contractors, if that makes sense.
So Illinois followed the path that a lot of people want New York to follow. Taking this, we've established the elements of 240 law. Taking the element of automatic fault on the developer contractor to proportionate fault. So if the contractor, if the employer was 70% responsible for the injury, after it's tried, the employer pays 70% of the damages. That's what every other state does. Plus, there's workers' compensation. My summary of workers' comp, you guys correct me if I'm wrong, but if a worker is injured and he's out of work, he gets up to two-thirds of his weekly pay, up to about $900 a week, $800 or $900 a week. All the medical costs are paid for, right? Basically. And the change to this law doesn't take away his right to sue if the employer was negligent. He can still sue, like 49 other states, he can sue. So Vincent, walk us through your real world. What happens in these cases? What are some examples so we can kind of liven this up with
Sure.
real world examples?
Thanks, Chris. I think the most dangerous 240 cases are the ones I call the unwitnessed accident cases, and we get tons of them, where guys in a room alone with a ladder or a scaffold, nobody's there to witness it. He says he fell off. 9 times out of 10, the ladder's gone. 9 times out of 10, the scaffold's gone. Nobody can take a look at it. And his testimony that the ladder had a weak step or the scaffold had a shifting plank is prima facie evidence of a violation of 240. And you have...
What is prima facie?
Prima facie evidence is he puts that in front of a judge, and if I have nothing to refute it, if I don't have a witness to say, no, it didn't happen that way, which a lot of times we don't. It's just the mechanics of what happens. He's in a room alone.
You don't see a lot of the other workers and supervisors rushing to the defense of the owner and contractor.
And they're not running to the courthouse to help you out either. So that prima facie case is he puts that in front of a judge, he's going to win summary judgment. And that's
Okay, so he's gonna
that's how easy these cases are for plaintiffs sometimes.
He's going to win summary judgment. It's reasonable to think he will win summary judgment. So how does that change the dynamics of the settlement process?
Summary judgment means he's now got a finding of fault against the owner and general contractor without a jury deciding it. A judge has decided it as a matter of law. That ends the liability case. He is now entitled to what he claims in damages. Now, you get a trial on damages, and I've tried these damages-only cases in the Bronx, in Brooklyn. It's the worst thing in the world to have to explain to the potential jurors that you're picking. By the way, a court has already decided my clients are at fault, but can you still be open-minded in terms of damages? You try to do it, but it's very, very hard.
Because of automatic fault.
Yeah, the jury, it's a natural human. Wait a minute, you're telling me, Pizzuto, a judge has already decided your client's at fault. They know nothing about the scaffold law. They know nothing about 240 and that we didn't do anything wrong. They just know as a matter of law we're at fault, and they're just going to be putting a number on plaintiff's case. And I'm standing up there trying to be as credible as possible saying, but keep an open mind. Keep an open mind on the numbers.
Because at this point in your trial, the whole focus is the amount of money to be paid.
That's all you're trying. All they're hearing is the plaintiff's testimony about how bad his life is, his doctors.
What's the practical impact on the settlement process? What does that mean?
When they're granted summary judgment, which happens often, like I said, mostly in these unwitnessed accident cases where you have nothing to refute their prima facie testimony, you go to mediation and you're only mediating the extended damage.
Which means they ask for a very large, potentially seven-figure, $2-3 million to settle.
Well, that's the other thing, Chris, is you take, what I would term not to be the worst injury in the world, a fractured ankle, maybe even if there was a surgery involved. An iron worker is going to get an orthopedist who's going to say, I will never put that gentleman back on a scaffold. Never. He can never do it again. And he's got his union contract. He's got his 3% increase. He's got his pension, annuity, topping out fund. The hard numbers alone, they're coming in with these economists who are saying, he's a 30-year-old guy. This is all he stood to make. And his doctor would never put him on a scaffold again. How can I be credible going to court and say he can go back on a scaffold again? Or a doctor, I get to hire a doctor one time to look at him once. That's how the rules are. Okay, my doctor looks at him once and says, oh, I think he could go back to work in that capacity. Meanwhile, his treating comes in, and he's going to have more credibility on it because he sees him all the time, and he's testifying, and this is what the plaintiffs can do. Pizzuto brought in a doctor. He saw him once. He paid him to see him, and he says he can go back to work. But my doctor, the guy I put on the stand, he sees him every day, he sees him every 2 weeks, and he says he cannot go back to this type of work. And the hard economic losses become huge.
If this was comparative negligence, if we were in the comparative negligence world, how would the dynamics change?
Well, if we have comparative negligence, I could just give you some real-world examples. I had a case where a guy is a sheetrocker. He testifies that his boss is on the way with a scaffold, but he doesn't want to wait. He takes two A-frame ladders, puts them about 6 feet apart, and takes one 2x4 and puts them in between, and steps up on there and falls off. 240 granted. 240 granted because there was no instruction to wait for the boss. That's a key in the case as well.
We're automatically liable for that injury.
Automatically liable for that injury. We had a high-end, I call the iron worker cases really the high-end cases, but we had a guy on a float scaffold, which he probably set up, with a harness on, with a lanyard, with tie-off points. The lanyard is not connected to anything. It's hanging down. The float scaffold fails, and he falls 25 feet, massive brain injury. If the lanyard had just been clipped and the tie-off point was right there, the failure of the float scaffold would have been trumped by the lanyard being on. But there's a case out there called Aragon that says the failure of the scaffold in the first instance trumps his failure to put on his lanyard and tie it off. And it's a case called Aragon. And he won summary judgment, damages only case. You know, another huge thing is instructions. You have to, we're talking a lot about, you know, culpable conduct, you can't raise it as a defense. There's a defense called the sole proximate cause defense, which it's where you can prove that what he did was 100% the cause of the accident. And we try it all the time. The case that started it was a case called Weininger, where a guy took an A-frame ladder, opened it up, climbed it, and then stood on the metal brackets. The Court of Appeals said, all right, we're not going to give you 240 for that. And then another case came down, Blake, and we cite it all the time because it had very nice language for us, where a guy took an extension ladder, opened it, but didn't open it all the way, and the hooks didn't attach to the step. He climbed up it, it curled into himself. The court said that's going to be, we're going to let a jury decide whether that's the sole proximate cause. But how often do you have a fact pattern like that? You usually don't. And what plaintiffs always come up with, well, there were multiple things wrong, and even if he did this wrong, like the case I told you about with the float scaffold. The float scaffold didn't hold him up correctly. It came off, so that trumps his failure to tie off. And somebody mentioned alcohol before. I can give you the cases. We've got documented cases of a guy going to the hospital with a .23 blood alcohol content, but the scaffold didn't have rails on it, so that trumps, and he wins.
So I don't think anyone is saying, I mean, no one is saying don't give an injured worker his due if an employer was negligent, right? No one's saying that. But what the problem with this statute is that it disconnects the worker for his responsibility with respect to safety. It disconnects his own responsibility for safety. And that's inconsistent with the whole idea for safety. Yeah.
Chris, let me define how we're defining reform. The legislation, which has been introduced year after year after year, simply would allow us to present evidence in those cases when there was negligence or training or negligence on behalf of the worker, and to let the jury decide the extent of the damages. That's the reform that we've been searching for 20 years.
To be like 49 other states, by the way.
To be like 49 other states that we usually are able to get past the Senate. We can't do that this year with the new power sharing agreement, and it always gets defeated in the Assembly. But that's reform. Allow us to present facts.
And we have that in 241-6 cases. We have that right. In 241-6 cases, which usually deal with a trip and fall in a passageway over scattered material, it's still a strict liability statute. If a jury finds that scattered material shouldn't have been there, owners and general contractors are strictly liable, but 241-6, you're allowed to argue the culpable conduct, which is, okay, there was a lot of scattered material, he could have got around it, and I think that's all we're asking for here is the ability in the gravity-related cases to present that same type of culpable conduct evidence and let a jury decide what the apportionment is.
But you might not be asking for that. This is good business for you.
No comment.
So tell us about what I would call the 240 labor law, scaffold law plaintiffs bar. And what do they do to get these cases? Please.
I mean, I think we all know the players. I think they have very strong union ties. I've heard stories that when there's an accident, phone calls are made, and if the accident is, you tripped and fell on a big pile of debris, the answer is no, you didn't. You tripped and fell on a little scrap piece of metal that was on a staircase. That's what you tripped and fell on. Now, those are the stories I've heard. But anyway, you see the same players. Certain firms seem to have connections to the iron workers, certain firms to the carpenters, certain firms to the electricians. And they know how easy it is. These guys are brash guys. In 16 years of doing this, I've got to know them well. And they are ultra confident because they know if I don't have the evidence that I need to try to set up a recalcitrant worker defense. That's another one I didn't mention. Recalcitrant worker is a guy got an instruction, wear your hard hat, tie off. If I have evidence that I gave him this instruction and I gave him that instruction in connection with this job. It used to be that it had to be immediate. It doesn't have to be anymore, but I gave them this instruction. If I don't have that evidence, and these guys know it, they're ultra confident. I mentioned to you, Chris, one firm will do, if they sue the SCA or the city, they'll do the 50H exam, which is the initial deposition that you get of them. In a city or municipality case, they will take that transcript and turn around the next day and move for summary judgment based off that transcript. Testing you to see if you have anything.
Whereas in a comparative negligence case, there's a lot of work to be done, right?
Well, comparative negligence case, if you have comparative negligence, a jury has always got to get it. Okay, a judge can't decide it as a matter of law because a jury has to decide what the apportionment is.
That's work. That's hard work for a plaintiff's lawyer. I mean, that's not hard. Well,
it takes time.
It's the normal standard.
It takes time. It takes time.
What about? We talked about the 240 plaintiffs bar. What do you? Are they actually visiting construction sites and handing out business cards and marketing themselves? These law firms.
Chris, take that one.
We have AIG insures the World Trade Center site, as most of you know. On any site visit, you'll see these safety vests, and they're a little off color from the normal safety vests you would see. And we noticed that it's from a prominent plaintiff's firm. He had his people hand out safety vests with his telephone information and a description of how great a labor law attorney he was on them. We see this a lot. There's a lot of money in these cases, and not just the big firms that he's talking about. You want to see it? Open your phone book. Okay? Every lawyer who does car accidents, trip and falls, workman's comp, any other type of specialty, they list construction accident as one of the cases they're looking for. Because for a plaintiff's attorney, and not just the big firms, that's like the equivalent of finding gold in the street outside. They're easy. Other cases actually require work and risk. These cases don't. It's a very minor risk, and the rewards are big. And when we talk about insurance costs, going back to one of the other things, it doesn't have to do, I firmly believe, it doesn't have to do with how often accidents happen. It has to do with how often accidents become big claims and stop someone from working. And this is very unique to New York. The incentive of stopping to work is because you're certain at the end of 3 years of not working, you're getting a lottery-sized payday. If you have that certainty, that's a disincentive to go back to work. I think everyone knows that, particularly of construction workers of a certain age. You have a relatively minor injury, you have a lifetime of hard labor in your body. Now's the time to treat all your physical ailments attributed to this accident and get paid. It's pretty hard to tell people not to do that, especially with the very aggressive plaintiff's bar outside who's going to explain to them, you're going to get paid. Not you might get paid. If something happens, you might get paid, but you almost certainly will get paid. And then the last thing I would mention is within the unions, if you've been working in them a long time, you know, because this law has been around 40 years, it's gotten bigger and bigger and bigger. If you want to know why it's recently become more expensive, in the last 10 years, the unions, you don't need the plaintiff's attorney to tell you you're going to get money because you know someone at this point. If you're in the iron workers, the carpenters, the steam fitters, at this point, if you've been in there long enough, you know a coworker who's retired on a golden pension from a labor law case. So it's not hard to convince you to stay out of work.
So why don't we just open it up to the panel to talk about anything that you want to talk about. Ross had something to say. Just guys, talk about whatever you want to as a follow-up, and then I think we should open it up to questions. Jonathan, you good?
I was going to say that we had the same issue with the plaintiff's bar on our projects. The law firm, one particular plaintiff's law firm, sent folks down to our project and handed out vests, safety vests that have the picture of the attorney and the name of the firm and the phone number on the back. I handed out very, apropos beer bottle openers with the with the name of the firm, and of course, the very decorative little sign you put on your refrigerator. So just in case you may be, having a snack and thinking about a lawsuit, at least sitting right there, his smiling face. So, and I gave it to Mike Elmendorf actually a couple of weeks ago after we went up to Albany. One other issue I wanted to mention about an impact of summary judgment in the 240 case is that after you have summary judgment, the case may wend its way for a while as the case bills and more not injuries, but more aches and pains, whatever issue the contractor, the construction worker may have had, somehow that could get into the case and it grows. It may start with a broken wrist, and then there's something wrong with the shoulder, and it goes from there. And really, the plaintiff's attorney's got nothing to lose because he's going to get money. Everything has already been determined. But once summary judgment is granted, interest begins to run if there is a subsequent judgment at the statutory rate of 9%. So that in and of itself, I know when we've talked about settlement at the SCA of some of these cases, if we go to trial and you lose and then there's an appeal and what have you, that judgment is running at 9% interest. So I know I'd like to get 9% interest on my 401k, and that just doesn't happen anymore. And the last thing I wanted to mention, because we've talked about the impact of 240 on small businesses, the SCA has a very comprehensive MWLBE program, including what we call the mentor program, where small minority women-owned businesses take classes for a 4-year period of time. They bid work with their peers only, and we provide the insurance. However, the cost of our wrap-up insurance program, our own controlled insurance program, is growing at such an alarming rate that our OCIP could be in jeopardy. And if that's the case, we are not going to be able to have a mentor program like we've had over the years because these contractors can't get their own insurance. So programs like ours, and we're not the only one in the state, are in jeopardy as a result of the increase in costs borne by 240.
And I think that's a key point. And following with that, and along with what Chris said, is the comparison that we always are trying to get to is this New York versus Chicago. And when Chicago repealed it in 1995, there was a great positive impact, which there was. But in my opinion, Chicago never reached the saturation point that we've reached here. You look around the room, and there's many insurance brokers here. In circa 1990, you had a large opportunity in Chicago. You could pick up the phone and call any one of the many underwriters that could probably fill this half of the room. Right now, we, as insurance brokers, pick up the phone and could probably call people that couldn't fill this first row. Maybe 3 or 4 people that would even look at you. For insurance. You know, the underwriting communities have left. Insurance carriers have exited New York. That did not exist in Chicago because of this issue. Because you have a frequency issue with now it seems like every worker, particularly every union worker, is aware of it, and they're looking for it almost, as well as a severity issue with the average claim payments in this area trending $4 million. And those two scenarios, in my opinion, did not exist in 1995 in Chicago. And they exist right now.
So I guess everyone's really asking themselves, so what are we doing about it? There's been an organization formed, the Lawsuit Reform Alliance of New York, Tom Stebbins, who's done an excellent job of getting a number of different organizations involved in lobbying for this effort. If the User Council is not a member, I would strongly suggest that they become a member. I think, thanks to Chris, we have the Real Estate Board of New York geared up in a way that we've never had before, which is very important politically. There's no question about it. In discussing this with Rebney, we've decided that Rebney will take the lead and talk to Gary LaBarber, the head of the Building and Construction Trades Council in New York City. I have had some conversations with Jim Cahill, who is the State Building Trades president, who he knows it's a crazy law, but in the world of politics and labor, they're not going to give up anything without getting anything back, but is at least willing to have a conversation with me about it. And we have to continue to press. Do we have enough time in this legislative session? Probably not. But this is a fight that's got to continue this year and into next year, because again, I'm going to repeat what I said. The economic survival of many construction companies, many construction projects, the economic viability of this city and state, I think, is seriously at risk unless we can get some type of amendment to this law. So we have to keep trying. I think the environment is more receptive now than ever than I can think of or have seen with respect to trying to make these changes, because it's impacting public projects, private projects in times where the economics of building are still difficult. Financing is still difficult on the private side. I wouldn't expect any large increases on public capital budgets over the next couple of years as municipalities across the state deal with their fiscal issues. Again, you say to yourself, you know, you look at major cost sectors, and everybody knows in New York City we have the highest construction costs in the country. I mean, Steve Ross says that to me probably about once a week. And no one really focuses on this element of it. And so we have to have reform if we're going to move forward. We have to, and everybody we talked to, when Ross was up there, you got to split the trial attorneys from labor. And I don't think it's even worth a conversation with the trial attorneys. So we have to have the discussion with labor to try to reach some type of middle ground on this.
Lou, there was a visit to Albany within the last 3 or 4 weeks. What was that about?
I was unable to go. My senior vice president was there, but it was organized by the Lawsuit Reform Alliance. I know Joe Hogan from AGC, Ross was there. Another public agent, TA, was there. There were a number of people, and they just went visiting legislator after legislator, representatives in the governor's office, pleading this case. The reports I got back, and probably Ross can report on it better than I can, when you went to the legislature, from the key players, the first question is, so what's labor's position?
So who else has Kevin or Greg, do you have anything else?
I just reiterate what Lou was saying again. You know, these deals are tight, right? But to make the decision to go or no go, every underwriting is tight. Financing is tough, and this is a very, very meaningful number. I mean, this is really probably the most meaningful number of the entire budget, and this increase is costing jobs for sure.
So this is important because I think up till now, Lou, correct me if I'm wrong, but a lot of the voices in the reform have been contractors, maybe some carriers, but now owners are really paying attention to this. I mean, this is about future projects. It's also about current buildings, because 240 applies to workers in the existing buildings too, right? Anything gravity related.
Oh yeah, I mean, that's why, again,
and then we just had
your efforts, okay, it's the first time in 20 years that I think we have a shot at this, because you've got owners really organized and saying, hey, this really impacts me. If we don't have owners leading the charge on this to go into the governor's office, we're going to just continue as contractors and any other of the constituents that join this as beating our heads against the wall. But I think the owner community is really, really engaged, and we're going to have to collectively make that pitch, because I can tell you that at one of the governor's the New York City Regional Economic Development Council, where labor has a seat, and from the panel, the issue of 240, 241 reform came up. Labor objected very vociferously to them, and they couldn't even get the votes to recommend to the governor to take a look at this.
Vincent, Kevin, Chris, anything else?
Yeah, Chris, I mentioned earlier just about, I mentioned some of the defenses you have. They're very limited, but one of the other problems that we're having here is the Court of Appeals, which is the highest court in the state of New York, has really expanded the breadth of the types of accidents that this statute covers, and really the types of accidents that they are going to deem gravity related. Early on, there was a case called Ross, which seemingly or arguably limited the cases to a worker falling from a height or something falling from above onto that worker. That is just not the limitation anymore. It's very, very broadened. A case came down called Runner, where they were lifting a huge spool of wire up a staircase. They tied a rope to it, and Mr. Runner grabbed onto the rope and became basically the human counterweight to this roll of wire. They obviously miscalculated. The wire went shooting down the steps, and he was pulled forward, but like into a bar that was across a doorway. He obviously didn't fall from a height. Nothing fell from above onto him. And the Court of Appeals said, no, this is still a 240 case because we are going to, if it's gravity related in any way and there's a protection that could have been used, we're going to find it to be 240. And what they were doing was they were looking at the height differential between the wire and the bottom of the steps. And this just broadened it so much more. And now we're getting gravity-related cases. I mean, there are cases that say it can't be tangential to the effects of gravity, but the current makeup of the Court of Appeals has been very, very plaintiff-friendly. I said the pendulum has swung back from when they decided the Blake case and the sole proximate cause case. And just another example, there's cases that say if a plaintiff gets hurt while trying to stop himself from falling, he still wins 240. And just as a quick example, I had a case, and I got my name on it. I still can't believe I lost it, but a guy was using a circular saw on a concrete foundation. He's standing on a concrete foundation. It's got a trench next to it that's uncovered. He slips on weatherproofing that had not dried yet, which, obviously I think he should have let dry before he stepped on it, and jammed the circular saw into his hand, one hand into the other. His argument, when I moved for summary judgment, was, well, I was afraid of falling into the trench. Despite the fact that he already testified, I instinctively looked to regain my balance. And the lower court, Supreme Court, found that to be a 240 case, summary judgment granted, and it was affirmed on appeal. So that's just this is guy not even close to falling from a height, not even close to something falling on him, cut himself with a saw, and they found that to be a 240 case. So one of the other problems we're having is the Court of Appeals right now is very, very plaintiff-friendly, and they're finding 240 cases where previously there weren't ones, and the breadth, they're expanding the breadth of what this statute is covering.
Thanks. Chris?
Don't feel bad. I have one of those appellate cases too. If you Google his name or mine, where I went to the first department and the worker jumped from one level to the other, and but the level that he landed on didn't have a guardrail, and he continued to fall. So even though it started with his own jump, the first department decided to concentrate on the lack of railing. It's always fun to have people cite that case against me.
I can't believe you lost that case, Chris.
I can't believe it either. Can't believe it either. And if that was the worst of the case law. But listen, I did say at my first comment was this started as a good law. And the debate centers around what this originally started as, that this is somehow a safety statute, and somehow it makes the site safer. Those of you in construction can probably attest, if you haven't heard of labor law, how did you think it actually made your site safer? It didn't make your site safer. You looked at OSHA, you looked at New York regulations. You didn't look at some antiquated law that's never used proactively on the site. It only comes up after an accident. So the arguments that a plaintiff's attorney will make, or that even the labor might make, that this somehow promotes safety is really undercut by the fact that it's not part of anyone's safety plan. It's an old, not updated law. I would just point out one thing. The people who really benefit, the ones who are getting these huge awards that are driving up the insurance costs, are very small in number as compared to the total New York job market for construction. We're talking about hundreds of people, but each one getting multi-millions of dollars. But as compared to the thousands of construction workers who are now being hurt by the lack of construction, we're really disproportionately benefiting a very small group of people to benefit mostly the plaintiffs' bar and perhaps some other parts with the unions, but not really helping the labor market in New York, not with safety and not with jobs.
Great, Chris. Thank you. So I stand by my statement that this is the best panel ever assembled to talk about this issue. Thank you guys for, it's not really just the organizations, it's the people who are representing those organizations. So thanks for bringing your expertise to share it. Really, really terrific. So let's open it up to questions. If you have questions, please raise your hand and we'll get you a microphone and let's open it up. Joel, you.
Thanks, guys. It appears that the real challenge here is labor. That's very obvious, and I'm wondering with the realities of more and more carriers that are starting to not write policies in New York, as Kevin and Chris have talked about, and the reality that the developers are not going to continue developing these large projects, or at least it becomes a barrier to developing these projects, whether those realities have created any inroads with labor yet, and if they haven't, does it appear to at least be on the horizon? Maybe talk about that.
How do I answer that? I think the last point that was made was a very critical one, that it's a very small group of people that have a very large disproportionate amount of the judgments. But in my 25 years in dealing with organized labor, they recognize the logic of what we're saying. But in pure political terms, they're not giving anything up unless they get something back. And I've had at least one conversation with the State Building Trades president who was at least willing to talk to me. He gave me an idea of some of the things that he would be thinking about. I don't want to mention them, and I'm going to be pursuing that. But you never know. Because, I mean, we're talking about it and focusing in on a particular number of trades. No matter what you do from the leadership down, those trades will have their lobbyists in Albany fighting anything we do. So that's why it's really important that owners get involved in a major way to blunt that. And all we need them to do is to be quiet. We don't need them to advocate. We just need them because we know the trial attorneys are not going to be happy with any settlement. So I don't know. I mean, there's no way for me to tell. I'm a little more positive this time than I ever have been before, primarily because of the involvement of New York City, of REBNY.
Questions? Other questions? Yes, sir.
Two questions. One for the lawyer. One of the things that I've heard now in the legislature that I've not heard before, and it's kind of an interesting one as I traipsed around a few weeks ago, is that they're very, very concerned that if we should reform this law, the courts will be overburdened by cases because now we'll actually have a defense and the courts will be affected. That's one. And then for the insurance ones and the owners, one of the other things that we're seeing now, and you mentioned it, is the lack of availability. And so we're seeing an additional risk by subcontractors and contractors going to the non-admitted lines and having crazy exclusions like 240 exclusions, over 3-story exclusions. And if folks aren't paying attention to what's actually in those policies, they're put at tremendous risk. So I'd like maybe comments on both of those.
I asked to take the first part of your question only because it's something that interests me and it interests carriers in general, is the legal spend on defending these cases. And one thing to keep in mind, the idea that the law would change and there would be a lot more appellate case law is very undercut by a Westlaw search. Type in Labor Law 240 in any legal database. Last time I did it, I came up with 4,000 opinions. This statute involves millions of dollars. Don't think that carriers, defendants don't litigate it now. We challenge it as much as we can. We push the limits as much as we can. We're losing at the moment, but we do. So this will be challenged whether you change the law or not. And the courts are very well aware that this will keep being challenged on the appellate level. So whether the law is changed or not, it's not going to change that 4,000 cases that have already been litigated. There's still going to be 4,000 more whether they change it or not.
Well, good, because that's what I told the legislature.
And if I could add to that as well, I think also with a culpable conduct defense available in 240 cases, plaintiffs' lawyers are going to be a little more circumspect about the cases that they sign up. So you might see claims go down.
I definitely agree with that. Have you seen in Illinois, for example, cases have gone up or down?
I think Kevin, did you mention what happened in Illinois? Was there any assessment of how many claims?
I did not see an assessment of actually how many claims that were litigated versus
But we know construction went up and fatalities went down.
Fatalities went down, construction went up, and union membership went up.
I would venture to guess that claims went down in Illinois as well, because it's just, if you have a culpable conduct offense and you don't have strict liability anymore, you know, cases for plaintiffs' attorneys are an investment in time and money and experts, and you know, if it's not the slam dunk that it once was, they're going to be a little more circumspect.
I can say generally, we write Illinois. Since February 14th, 2005, when they repealed the law, There was some older cases that continued to be litigated, but after those worked their way through the system, claims went down. Because they didn't, just one thing to keep in mind, if the laws were formed along the lines to add culpable conduct, we'll still have the highest protection of any construction workers in the nation. Illinois got rid of everything. You have to prove actual negligence. Here, you would only be able to hold their negligence against them. New York would still be the most protection after this reform. Illinois got rid of everything and went back to what every other state does, which is negligence.
If we can get some numbers, by the way, if you see in Illinois, any numbers to back that up, as I talk to the legislature, that would be helpful.
We're working on it.
But Joe, just the second part of your question, you're 100% right. When you squeeze the balloon in one area, it's going to expand in other areas, and you have cost, you have limited access to insurance carriers that will write this. Just from pure economics, it forces other players, or look to other players to write your business, which then will have a trickle-down problem down the line where claims may not be paid that should be paid, and exclusions that are there that you don't expect to be there.
The numbers I've seen on Illinois are as follows. Since the act was repealed in 1995, the number of Illinois construction employees has increased. The number of construction employees has increased 28%, while Illinois has experienced a 30% decrease in fatalities. And that the overall worker injury rate decreased 53%. Yes.
Most city and state police cars are fitted out with video systems. Technology exists that even police officers have lapel-mounted cameras. Okay, you got cameras mounted in the back of taxis that take your snapshot when you come and go. How come, given the difficulty of changing the construction laws and the battles that everyone's facing, how come the construction sites are not properly lit up with wireless security cameras so that you guys have evidence and proof to help substantiate defense for some of the claims that you're fighting?
Then you'll see what's actually behind those walls.
Yeah. I can see that one. So that is an excellent point. And we've been doing this related from our last building at MEMA, where we had essentially 2 cameras at every floor, right? And for a 60-story building, and cameras everywhere. We decided to go nuts on cameras, and it worked. And our claims were low there. And for now going forward, that's our standard, right? Cameras everywhere, so that we have evidence. People know there's cameras, right? And so that's actually half the battle. And so far, knock on wood, we've had very good luck with lots of cameras. So that's a very good point.
Well, I mean, it wouldn't pick up everything. The worst example I've seen in 240 is a worker that brought a ladder to a site, and it was held together by wire. The top was held together by wire. His job was to stand on top of that ladder and do some work. The wire snapped, and he fell and hurt himself. So the claim is now probably going to settle at $2 million because he brought a ladder to the site that was held together by a wire. Now, I don't know that a camera would pick that up. And by the way, that suggestion, which is good, increased costs ultimately to the owner. I mean, that does increase costs. I mean, could we have multiple site safety people on all of our jobs, right? In this case, it would literally almost need a 1-to-1 ratio. We have 1,000 workers on a job. Do we need 1,000 safety workers with this law to police every action of that worker, of those workers? I mean, there are really ripple costs to kind of design a safety system around this law. Yes, sir.
What is Governor Cuomo's position on this relative to his, make New York competitive again?
So what's Labor's position on it?
Yes, sir.
I have a question, maybe as a practical matter. Let's say we're working in a cooperatively owned building, co-op, and I think you mentioned the law does apply to existing buildings as well as new construction. And we're in a pre-war building with maybe a 16-foot ceiling. So the shareholder who lives in one particular unit wants to bring in a contractor.
You trying to get free legal advice here from Vincent?
No,
okay. He'll do it.
No, typically a shareholder is obligated to bring the alteration to the co-op board, et cetera, et cetera. Who is the owner? Let's say in one apartment, somebody's on a scaffold and literally painting the ceiling in a $5,000 job. They fall off the platform. Is it the board or the ownership? And if so, why would they ever give approval to somebody to paint the ceiling?
Vince?
There is a single-family exception to 240. But I think there's also some recent law on co-ops, and that 240 does not apply to co-ops because it shares in the co-op as rather ownership of the building.
Well, let me add on that a little bit. And we're all familiar with Hurricane Sandy and the devastation that hit our area. And through FEMA and the city of New York, a lot of general contractors stepped in to really to do work or try to do work to go in and repair out homes, pull out the drywall, rewire electric, and rewire boilers and heaters, et cetera, et cetera. One of the firms actually pulled out, and insurance was a big part of it because they couldn't get it. The other firms who were involved in it were staggered with the actual numbers that the insurance cost. And when you do the rate online, it was literally tens and tens of millions of dollars just to cover insurance. We had several lawyers looking at it and it was all driven by 240 because you're going to have workers going into people's houses, whether they were tripped and fall, although there's an exception for single-family homes in some instances. It doesn't always apply based on the type of contractor that's doing the work. And it was and the reality was it's being paid for by the city, it's being paid for by taxes and through FEMA, but it was just that many more homes that couldn't be touched to because the millions of dollars that were spent for this particular issue could have repaired tens of thousands of more homes.
A couple more questions. Ma'am, you had one?
Now, ma'am.
Sherry.
I'm World Trade Center, so our insurance line item is way too visible, as is the line item we put into insurance for every project. And in some cases, it's a go or no-go on a project, because that line item, when you take all the insurance, not just the GL and the excess, run anywhere from 10 to 12%. But the issue is we're having two different conversations. Not us in this room, but us with labor and us with the assembly up in New York. And these two different issues are, we're talking about safety. Chris said it was a good law to begin with. It was. But that was when workers' comp was in its infancy. Once workers' comp established itself, now we're over 900 a week rather, the need became less. And more importantly, when OSHA came in, the need became less. The problem is that these workers can afford to go out. These plaintiffs' attorneys are saying, don't worry about it. Either we'll fund you during that period because the probability of settlement is 99%, or you're collecting your workers' comp anyway, so you can afford to be out while we sue for the jackpot. And the problem is trying to get that on paper to show the assembly, and also to get on paper for even the fact that I had one building that was just put up. I had less than $2 million in workers' comp claims, and on $750 million bill, that was very, very good. I have over $30 million in labor law cases emanating from 28 cases, most of which were worker fault, but it was found there was at least 1% negligence. So the real problem is showing labor that they're still getting their money, they can still sue, they're still going to recover, and less than 5% probably if we look at the stats, or 1% in my case, less than 1% of the workers are taking so much money out of the pool that people aren't able to develop, and therefore there aren't jobs for the other 99%. And that's really what the message is about.
Chris, if I can, because this issue has an impact on one of the panelists was just mentioned contractors responding to catastrophes and emergencies, and that's an element of this that I think, again, where the city is the future of the city is at risk. I happened to be involved in that, got called down to City Hall by the mayor, and when we asked the question, will we be indemnified? Well, we don't know. Well, you're not getting anybody to even bid this job, and we had a very, very difficult time even identifying 5 or 6 contractors who were willing to take on the work. There was a very negative experience by the contracting community in responding to 9/11. And if we don't find a way to address these issues...
Is this because of 240? Partially, at least?
Partially. And the indemnification issues, there were some major companies that almost went bankrupt in responding to 9/11. And no one was going to put themselves in that position again. So it became very, very difficult on the business conditions of responding to an emergency like that and getting people to do work with all the other problems that come, lack of payment and all the other FEMA issues. The city did a remarkable job in managing that process, but there were a number of players who wanted to come to the table, were not prepared to take the risk because of this and other insurance issues. And I think it's a national problem. It's particularly important in New York because of 241. You're not going to find a lot of major contractors who are going to be responsive in trying to address whether it be weather-related tragedies or any other kind, and put their complete businesses at risk.
Who has? Yes, sir. Last question.
To the developers in the room, how would you describe the impact of the labor laws added 4% in construction costs in terms of hiring labor or union workers?
Well, I mean, like I said, it's a it's such a major line item. So the impact, it will actually stop jobs. It'll stop, and so people won't get hired. It will definitely. Are you talking union versus non-union, or? Yeah. I mean, hypothetically, it puts pressure. That line item puts pressure on all the line items. So frankly, yes, it has. It'll make people look more closely at various costs of union versus non-union, and that will have impacts.
I think one answer is that it forces developers to look at all costs.
Right.
And one of those line items is labor cost. And these days, a lot of developers are looking at and exploring non-union contractor options. So, I mean, it's a real irony that the existence of this law is actually causing developers to go out and hire non-union contractors to do jobs. Thank you.
Thank you, Chris. That was great. I know we're out of time, but one more real fast question. A lot of owners here today. Today in the city, you've got metal maintenance contractors at buildings, you've got tenants doing fit-out work, you've got maybe some stores being built out, maybe a coffee shop, maybe a newsstand, maybe a small shop somewhere. How can an owner protect him or herself against these falls? Or is it just, is there no way to write into a contract with a tenant or a contractor?
I mean, one way that owners do protect in the traditional setting is getting contracts with the contractors and then running them down to the subcontractors that they will be indemnified to the fullest extent permitted by law, and requiring contractors and subcontractors to buy insurance and name the owners as additional insureds. But in CSIP situations or OSIP situations, there's the anti-subrogation rule where the named insured buys a policy for all the contractors and subs. And my understanding is that's a cost-cutting method. But when that happens, the anti-subrogation rule doesn't allow you to enforce your contractual rights. You can't subrogate against your own insured. So there are ways for owners and GCs to attempt to protect themselves through contract. But I don't think that solves the overall problem that these folks are talking about with just the added cost by the very existence of that law.
Great, thank you. Thank you, Chris, and thank you to all the panelists. Thank you all for coming out in the rain. Please grab a flyer on the way out. You can see Sarah or Joel if you want to join the council. And I hope to see most, if not all of you, at the spring reception in June with the date to be announced. And thank you all very much.